when should companies have a relook at the third-party data processor agreements to obligate them with DB compliance? So let's look at the subset of contracts that will have to be renegotiated. All vendor contracts will have to be renegotiated, right? All affiliated contracts, processing agreements, server agreements will all have to be renegotiated. So you imagine if you are a large company dealing with thousands of such contracts, you would probably have to start sooner than later. To give you an indication, some of our clients have already started relooking at. So the first step in relooking at third-party data processor agreements is to set in place baselines and standard forms that you would want to implement. Many of our clients have already started doing it. One or two, we may be at the end of the consultation in that regard. That's because they anticipated well in advance that this law would come into place. But when should you do it? You should have the baselines and the templates done right now. Then you should have an inventory of all the agreements and should take a practical call on how long these negotiations would take. In my opinion, you should start at least, if you think it'll take 1 month, you should start 2 months before. If you think it'll take 3 months, you should start 6 months before. Because there will always be, and this is from experience, but there will always be people who are going to disagree, going to ask questions, going to want to have their lawyers involved. There's going to be a negotiation. So the time to start is now.